All right, so just gonna kind of dive in here, piggybacking off of what I just said. I don't really have to pull up too much documents because you have a personal level of responsibility to do your own research. These templates are pretty much the result of our research and the research of the entire community that's been out here researching these different things about the law, and commerce. I've always been the type, we've always been the type to fact find and fact check and look up all these things that's out here. And then that's what we build. We build on where we find the truth. So, let me see if I can find my notes. I do have them here. I do have them here. So let me see where I'm going to position these notes. Now I'll bring them over here. All right, so I'm going to keep looking over here because I have some notes of different things that I wanted to catch, that I wanted to capture. So again, don't get wrapped up in thinking step one is like you can't do any of these other things unless you get step one, because when it comes to nationality and status correction, this is something that you should really research, think about, join a temple or visit a temple. You see a Moorish American in your community, somebody that ask them, get your information, go to Facebook, join some of these groups, and also understand so-called African American people that watch this, because I personally don't believe you're African American, but this is, we're going to focus more on the personal status correction stuff. But I want to tell you, the majority of people who proclaim their nationality as Moorish American were once ignorant of these things, just like you may be. It's just like going into a Christian church. They're still going to have their character flaws, their ways about them, and it's going to be based off of how they're raised in their background. So don't let how other people are acting, right, allow you to miss something that's potentially for you. So do your own research, right? Okay, so, but I put step one there because nationality is most important with anything, because it's from your nationality or your nativity where your rights originate from, if you will. At least that's what has proven to be true to me in my studies. So the first thing is we have a revocable trust. Now, the key with the revocable trust, I'll just say briefly since I'm thinking about it, what makes a trust revocable? What makes a trust revocable is the grantor, the person who has the authority to set out, let's say, the original purposes, terms, and policy of the trust. The grantor, he has the authority, whatever, because basically he's putting some type of finances, funding, or property in trust, and he's giving it to someone who's called the trustee, and he's giving them these initial terms and purposes and regulations. When the trust is irrevocable, that means once the grantor gives him that property and he gives him all the terms, he can't really change his mind or take it back. In this case, the trust we're doing is revocable. This means the grantor remains, he maintains some type of control over the trust res, the property, and different things. So he can give a power of attorney for someone to do something with the property, then he can revoke the power of attorney, right? He can, the grantor can technically act as a trustee in a revocable trust. It all depends on how the trust is set up. Usually when you hear people talk about living trusts, I've never really heard of a living trust that was irrevocable. I'm sure it probably could happen, but most living trusts are revocable because the grantor, you or whoever it is establishing a living trust, has some type of authority and control over the res of the trust. So when we're dealing with personal status correction, because the focus is always the estate, right? We want to deal with pretty much a living trust, because you have to be able to do the business and make decisions, right? And write the policy as you learn it and maintain the position as the trustee. So you may also, and at some point in the future, under here, we might put family trust. We may do a revocable trust, or I didn't call this a living trust, but that's essentially what we have here. And we may do a family trust. You know, whether you do a revocable trust or a family trust, well, if it were me, it would kind of depend on the status of my family. You know, does my wife understand some of this stuff? Is she willing to be an executor, or my other, co-part? And if not, then I'll probably just roll with the revocable trust. Or if I had someone else in my family that could act in the capacity as a successor trustee and maintain the business the way that we want to maintain business, in the event that something were to happen to myself, if they were directly in my family, I would probably do a family trust. But the way that this is set up here, it's just for an individual to do a revocable trust. Now, why do we want to do the revocable trust? Well, what we've learned is that it's very important that the revocable trust connects to the will. And we have this set up inside the templates. I'm not going into the templates right now, but you know what I'm going to do? Y'all have to excuse me. I'm not really trying to be cool or nothing like that, but that glare, I don't really like that glare. It's hitting me in the eyes. It's kind of too bright. So I'm put these sunglasses on. So please excuse me. I ain't trying to be cool or nothing on you, but this feels better. So there's got to be a connection between the revocable trust and the last will and testament, if you want to keep the estate out of probate. I highly want to encourage people. As a matter of fact, I have a will on record and I need to redo it, because when I was putting the will on record, it was more so to break through these different barriers so we can set up this outline and we can know how you can get these things done. So I do have a will on record, but it's not to the extent of what I can break down, what I'm about to break down to you here. Now, I've seen in real life, since I've been studying this stuff, at least two for sure, but I think 3 real instances of people who died intestate, means they passed form on this earth and they did not have a will on record. And I now truly understand, even though it was taught to me before, but now I have witnessed and seen that by dying intestate, you are, me personally, I'll say if it were me, I would see how that's creating a burden on my family, that is reducing whatever it is that they could have got from my estate, and it's allowing the state, somebody that I don't trust, that works for the state, some third party person, I don't know his morals, his background, or his prejudices, to dictate and direct the administration of my estate. So it's ultimately important that you have a will, right? And it's also, or let me put it like this, to say it properly, whether you have a will or not, it's ultimately important that you leave some type of properly recorded estate plan so that the plan can be executed according to your desire without you having to bring in some third party relationship of the court, unless that's what you want to do. But usually, I'll give you a perfect example. I had a friend who, and this is still ongoing as a matter of fact, my friend had assets which at one time after his passing was worth over $1 million, I'm sure. And then unfortunately, he died intestate, although he has one son, and his son is not of age. This is a personal friend, one of my good friends, as a matter of fact. So he was divorced, and because I knew about those accounts, I had to tell his family about the account. And he couldn't, and for them to get access to the accounts, they had to go through probate and go through this whole process with the publication in the paper to get a testamentary letter so that she could be appointed the executor for his estate for his son that was the guardian, which was the only survivor, right? Because he died intestate. So that whole process took 6 months of just running around to get paperwork. And that was probably a quick process because there was no challenge, except for the creditors that pop up and start sending bills in the mail because they want to get paid out, right? But long story short, by the time we got all the paperwork that's necessary, now, we're having other problems because of the fact that it took so long to claim the account. So now it's becoming, you see what I'm saying? So that, and even things in my personal family right now, it just, and so let me just speak briefly. Do your own research on it. I got other videos where we talked about this stuff back in the day. How does that happen? Because when one dies, to die intestate to means you don't have a will. You didn't appoint an executor, so therefore there has been no one appointed by you to direct your affairs. So the state comes in as an administrator, right? And administrators have to be paid. And the whole probate process, which involves way more many people than you wrote out into your will, everybody has to get paid, and it goes through a probation process of your estate where private instruments and things get created on the back end, right? And a lot of times it comes really right out of whatever property you have. We ain't even talking about QSIP search results and private security interest and things like that. A lot of it just comes out of whatever you have. So once I learned, where is it at? Let me click this link here, put it on the screen, because I can't give you legal advice because we don't give legal advice. So this is an article. You can find many more like it just by Googling how a revocable living trust avoids probate. And it kind of just goes, you could read this article and they'll tell you what I can't tell you because I'm not giving legal advice here. But the idea behind this is a trust, in a living trust, you can title property and assets, and you can hold those properties, those assets outside of your name, basically. They'll be held in the trust. You might be the trustee for your living trust, or someone else may be the trustee for your living trust. Or you may be the trustee for your living trust, and you may appoint a successor trustee for the living trust. Now, if you pass form and the state goes through the normal process that they're going to go through, and they don't find no will on the record, I believe, I'm not sure, but more than likely, you're going to be in a status of having died intestate, even if you have a living trust, right? You may think, well, it doesn't really matter. If I have all of my assets titled in the living trust, it really don't matter if I die intestate because I don't have anything there. Well, one, I would say, I think you do have something there. There's a bunch of securities and things that need to be redeemed. Hopefully, we'll figure out how to redeem them during your lifetime, but if not, maybe someone could figure out how to redeem them after your lifetime. So I don't think you really want to leave anything intestate. So I said all that to say this. There must be a connection to your revocable trust and your will. Your revocable trust titles all your assets. Your will, how am I going to say this? Your will is set up to transfer any remaining assets that are not in your revocable trust into your revocable trust when you pass form, with no other provision basically except for that. So the real key is that lets you know your revocable trust, which can be handled and managed like a private document. You have to make appropriate public record of it. We'll talk about that when we break down into this. But the key is you have to have it set up right, and you have to make sure that you have a successor trustee and that you really left the proper instructions as the grantor for that trust of how you want the estate to be played out. And you have to make sure that you have somebody to trust. If you really don't have nobody in your life that you can trust and you want your stuff to go to probate, I guess that's what it's for. You didn't have anybody trustworthy that you can, give the authority and set up your affairs so they can handle your business for you. So you just basically died intestate, like a ward of the state, letting them kind of handle everything for you. So this is important. So the keys is, again, titling all your assets in the revocable trust, or what some people may call the living trust, and making sure that you have a will, a last will and testament, properly recorded so that should you pass form and there are assets that are not yet titled in the revocable trust, that they'll be transferred into the revocable trust at your death, and that your successor trustee, in essence, will become the executor for your estate. So as long as these, so what I say what do I mean when I say there has to be a relationship between these two documents? The relationship is, if something were to happen and you were to pass form, one, your last will and testament needs to be properly on the record so it could be acceptable to the probate. And when they crack it open, it has to reference transfer assets into a trust. There can be no ambiguity about the existence of that trust. It must be evident. There must be a proper record of the existence of that trust, or you might be potentially setting yourself up for some type of issues or problems. So that's why I put the trust, the revocable living trust, before the will, because you want it in proper existence. You want to understand what we put down here, section 2.2, the trust registration statement, to show you the proper identification for the trust, if you will, so that we can understand what the trust registration statement is, so that by the time we're putting the will and testament on record, we will be able to transfer any assets remaining into the trust and positively identify that trust by the proper registration statement so that there can be no confusion, right? So eventually, once I get done talking about all of this, I don't know, it might be in a couple days or so, I'll start breaking into the layers and going into the documents and pointing out these things that I'm overviewing right now. So that's kind of why you see the flow going. You technically could still do the will and testament first, but you know, if you can't hold all of this in your brain and you got to see it on paper to make it all make sense, then you probably want to do it in the order that I set out. You know, we've been working on this master file for some time, me, myself, and at least two other brothers have been giving real good contributions, so we kind of know what's all in here. And also the way we set it up is there'd be other things that we're going to be adding in here under the appropriate step. So you can do everything in this order and you won't have to worry about starting all over or that you missed anything or something like that. All right, so let's see. Well, since I did this much, I'm going to take a break here and then we'll just go into another video.